We're here with Professor Sherrilyn Ifill of the University of Maryland School of Law, who just had a terrific discussion on the value of judicial diversity. Professor Ifill, would you mind discussing the two benefits of judicial diversity that you discussed in the panel?
Well, one of them I think most people are kind of on board with, the idea that the public has more confidence when they see a judiciary that's reflective of the society from which they come. And that's important. I mean, I don't want to minimize it because it's important that for their own legitimacy, that the courts have the confidence of the public. Judges don't have their own armies, they don't have police forces. They really rely on the acquiescence of the public, and that acquiescence, the willingness of the public to accept a judge's decision as final and to comply with it, is really very much dependent on the public's sense that that court is legitimate and that that court is entitled to deference and to respect. And so it's important that the public looking at the court has confidence in the court. The second reason I think is one that's more complex and one about which I'd hoped the confirmation hearings would provide a little bit more light, but which I think we really need to have as the subject of an ongoing discussion. And that's the possibility that judicial diversity makes judicial decision making better. Now, by better, I don't mean what many of the Senate Republicans seem to implicate, or even what the statement that was lifted out of context of Judge Sotomayor's speeches seemed to indicate, which is that a Latina or an African American would make better decisions than a white judge. But that judicial decision making as a whole is improved when you have judges from a variety of backgrounds and perspectives coming together in that judicial conference room in the Supreme Court in that slight percentage of cases in which judges do have to make decisions that are not clearly on their face apparent by the words of the statute or by the words of the Constitution or even by the facts of the case, but where judges really do operate in between the spaces. That in those cases, what we have are a set of judges who represent and who are reflective of the larger society, who are reflective of a variety of professional backgrounds, a variety of races, both genders, hopefully, and that they can come together. We saw that this term in the Safford case, in the case involving the strip search of the 13-year-old girl, when at oral argument, many of the male judges, this was across the ideological spectrum. I think it was, Justice Breyer who asked the question, this young girl was strip searched, well, so what? You changed for Jim, in middle school. Why is this such a harm that rises to the level of a constitutional harm? And it was Justice Ginsburg who at the oral argument had to kind of school her colleagues on what this might mean for a 13-year-old girl, that sensitive age of development, to be strip searched in this manner. And ultimately the decision in that case came out the way we didn't think it was going to turn out when we heard the oral argument. And I think there can be little doubt, based on what Justice Ginsburg said at the oral argument and what she said later in an interview with Joan Biskupik at the USA Today, that she had an influence on her male colleagues in explaining to them something that they did not know, could not from their experience have understood, but which she understood very personally.
Thank you so much, Professor Ifill.
Thank you.